that is why I say, Bill 10, as bad as it was, we opposed it. The process for its formulation was much, much, much more consultative than what we have now.
Welcome to Zambia Today Television, where stories unfold. Today, we dive into a developing political issue stirring debate across the nation, the controversial constitutional amendment process. Former Attorney General Musa Mwenye has delivered a stinging rebuke of the proposed changes, comparing them unfavorably to the Bill 10 process and calling for an immediate halt. Let's break it down.
1996, we had the infamous parentage clause. That constitution was amended. Why? To bar Dr. Kaunda from standing in the election by the MMT then.
Speaking on Phoenix FM's Let the People Talk program, Musa Mwenye did not hold back. He criticized the lack of broad-based consultations in the constitutional amendment process, calling it unusual and flawed. Mwenye noted that the 13 proposed clauses and the amendment roadmap lack critical details necessary for informed national discussions.
The process is very important. I've already said that we oppose the Bill 10 process, but it was much better than what we are seeing now. It was more consultative because there was an act of parliament that guided the process. There was a broad-based group that included several stakeholders that came up with the provisions. It wasn't come up from Ministry of Justice. It was formulated by the National Dialogue Forum, which was headed by Professor Muyunda Mwanalushi, and the secretary was Patrick Chisanga, Mr. Patrick Chisanga. And this broad-based group came up with these provisions that were handed over to the line ministers who presented them to Parliament. So for me, the issue is the how. The process is very important.
Right.
The current process is rushed. It is entirely driven by the government. When you look at the constitutional roadmap that we have been given, there is no place for a broad-based group that will consider. First of all, the constitutional amendment recommendations are coming from the government. The process of consultation is preceded by the publication of a bill. Previously, Bill 10 and the 2010 amendments presented by the MMD government were not formulated by the government. The bill came out of the consultation, not the consultations coming after the bill is produced. In this case, we have the consultations coming as part of publication of the bill for the amendment in Parliament. So we need to be very clear that what is happening now is unusual. It is not what we usually do in constitutional making in this country. In the past over 20 years, what we have done is let a broad-based group come up with the constitutional provisions. That's what happened under the National Dialogue Forum with Bill 10. That's what happened under the National Constitutional Conference with the Constitutional Amendment Bill of 2010. In this case, there is publication of a bill which is headed to Parliament, and as part of that parliamentary enactment process, the people are consulted. Now, you have already started the enactment process. You have already drafted the bill. Where is the people's feedback? Where is the input? Where is the bottom-up approach? And we need to rethink this process. In principle, constitutional review is good. If it is.
Mwenye warns that this move is dangerous as it does not clearly state its true intentions. He argues that if passed, it could erode the two-thirds majority rule in the National Assembly, opening the door to political manipulation in decision-making.
And rethink it. We all make mistakes. Sometimes we may have been advised wrongly. Sometimes we may have misspoken. It may be that this process is got good intentions, but let us give it the legitimacy by doing the right thing as we have done in the past. Let us follow the well-settled traditions of constitutional making in this country, which were formulated after years of contention. After we quarreled for several years, I was part of the Oasis Forum. People like Mrs. Emily Skazwa, if you remember,
Yes,
the Speaker of the National Assembly, the Right Honorable Neri Muti, Laura Miti, the late Ingutu Mutembo, Bishop Mususu, Reverend Japheth Njovu. We worked hard to fight for this particular process to be at least people-driven in terms of formulation and adoption of the Constitution. This is a well-settled process. We must not change it now. That with matters of the Constitution, development, poverty, it helps to listen to the wider population. And I think the advisors will do well to help in this regard, because presidents are busy. Sometimes they are preoccupied with so many issues. And I think it's incumbent upon those people who handle presidents to insist on some of these things. And I think there is still time. The constitutional review process that started in 2007, I was giving my comments that I've read on the 28th of September 2007. The bill was only presented in 2010, and President Mwanawasa had even died by then. So a process of constitutional making it takes long. Now, there are people who have said we don't need a broad-based group because it's not making the new constitution. Even the 2016 constitution is not a new constitution. It's amendments, because this is the 1991 constitution as amended. In fact, it bears tenets of previous constitutions, even up to the 1964 constitution. The only way you can come up with a completely new constitution is through what is called the Constituent Assembly, which would be constituted to enact it as well. But right now, we have amendments. Now, the Bill 10 itself was amendments. There was a 2016 constitution, if you remember, that was signed by President Edgar Lungu. In 2019, they brought amendments in terms of Bill 10, but they still followed the broad-based group through the National Dialogue Forum, whose procedure was guided by an act of Parliament in terms of composition, in terms of how to come up with the recommendations, in terms of resolution, and these were from church mother bodies, from government institutions, from civil society generally. That was the composition. But what we did is, when we analyzed what came out of that group, we saw that there were problems in Bill 10. And when we go now to the content of the current recommendations, there are problems there too, quite apart from the process. There are problems in the content.
Can you go?
As the debate over the constitutional amendments intensifies, we want to hear from you. Should the process continue as planned, or should it be halted for broader consultations? Drop your comments below and join the conversation. Don't forget to like, share, and subscribe for more updates from Zambia Today Television, where stories unfold.
This constitution, the 2016 constitution as amended, is the best constitution we've had. I mean, let's be settled about that. From 1964 to now, we have never had such a progressive document. There have been attempts to rubbish this document. There have been attempts to caricature it as a bad document. That is simply not true. And I'll say why I'm saying this. If you remember, Ambassador, we never had a running mate clause. Now, the president in waiting, the vice president, who, if anything happened in the office of the president, becomes president, is directly vetted by the people. We campaigned for that clause. We fought for it for many years. We got it in the 2016 constitution.